Recently, Nigeria got slammed with a judgment debt that the government said they knew nothing about. This was no ordinary judgment, as it involved a contract with an entity outside Nigeria's jurisdiction. What was this judgment about? Who was in charge of monitoring government contracts at that time? Can a government procure contracts without being aware of our own contracts? This is how we welcome you to your #1 legal talk show this week. I am Itohan Olomu-Agbodo. This is the Courthouse. After the break, we'll tell you more.
From Lagos
to London, from Johannesburg
for several years, our economy
to the United States,
identifying houses of worship.
We have all the world covered for you, no matter where you are.
Love with News is at the heart of it all.
I have experience.
We bring you our perspectives of stories behind the story.
The signs given to us for the entry of these things are before us.
Join us.
Join us.
Join us on this station.
You're welcome back. Recently, Nigeria got slammed with a judgment debt of about $9 billion for breaching our contract with an oil firm of explorers, an international firm, the P&Id, that is the Petroleum Industrial Development Limited. Thankfully, that judgment has been overturned, but we can't let the issue slide without setting the record straight and talking about the legal ramifications to avoid future reoccurrence. Joining us on the show today is a learned senior advocate of Nigeria. He is an arbitrator and he has many attachments to his name as well. He's also been a guest on the Courthouse for some time now. He is none other than Godwin Omoaka, S.A.N. We appreciate you making our time to be here again this week. And as always, we want to get a background of the whole P&Id saga. Please bring us up to speed with what the judgment was really about, what the contract was all about.
Well, the P&Id saga began sometime in 2006 when P&Id was incorporated as the British Virgin Island Company. Now, that company came to Nigeria through the efforts of General Theophilus Danjuma, the chairman of SAPetro, and they were to engage in a gas offtake project with Titaku, a company owned by General Danjuma in Badagry. For some reasons, that deal fell through. They couldn't proceed, but in the interim, General Danjuma had paid about $40 million to P&Id in respect of the gas offtake plant. And P&Id has supplied a PowerPoint design to General Danjuma. But subsequently, about 2010 or thereabouts, the P&Id, this was under, I think, the regime of the late Shehu Musa Yaradua, signed a GSPA. A GSPA is simply a gas processing agreement with the federal government of Nigeria, Ministry of Petroleum Ministry, to build a polypropylene plant in Nigeria, somewhere in Calabar, for the separation of gas. Now, there was supposed to be what is called wet gas and lean gas. Now, the idea was to process that gas to lead to the separation of the wet gas from the lean gas, so that Nigeria can be self-sustaining when it comes to gas production. P&Id would take the wet gas and, of course, export it. So that was the background to the GSPA. That was how the GSPA was signed, the gas processing agreement. But one thing that happened was that when P&Id came into Nigeria, there's clear evidence that it had no offices, It had no. It just had a handful of employees. It had no structures on ground. And then the federal government was able to enter into this GSPA with the. Unfortunately, the gas was never supplied. The project never got off the ground. It never got off the ground at all. And then P&ID made demonstrations to the federal government's ability to build the plant, and in fact applied to the Cross River State government to be given a land to site the plant. Now, what happened was that the Cross River State government gave it a letter of allocation and asked it to pay a certain amount of money, but P&ID never paid. So the gas plant was never built, and the project never got off the ground. But somehow, P&ID alleged that Nigeria breached the contract, the GSPA, by Nigeria's inability to supply it with the gas,
yes,
that it needed to process. Yes.
So
that was the dispute.
Okay, now
on the basis of that, on the basis of the alleged breach, P&ID now went to arbitration, and in 2017 got an award in the sum of about $6.6 billion against Nigeria. That was the original arbitral award. Now, that award was interest was attached to the award at the rate of 7% per annum. And as at the time the award was, Nigeria's application was granted this year to challenge the award. The award had risen to about $10 billion. That's just a big background of how we came to be where we are at the moment.
Oh, thank you so much for bringing us up to speed with the background to the P&ID whole saga and the history behind it all. Now, looking at this issue of governments entering into contracts with external bodies or signing agreements with external bodies, who basically is in charge of monitoring government contracts at this time, even the period where the Musa Yar'Adua administration was negotiating the contract with the P&ID and all that, which body, agency actually monitors this type of contracts in Nigeria?
Now, that's a very good question, to be honest. Now, the monitoring of contracts, I believe, we have the Attorney General of the Federation and we have the Ministry of Justice. I believe it should be the responsibility of the Attorney General to coordinate all contracts as the Chief Law Officer of the Federation. But one thing you will find in practice, as a practical matter, is that all federal government agencies and departments, for instance, the Federal Ministry of Petroleum Resources, the NNPC, they have various legal departments. Now, these legal departments, some of them have lawyers seconded from the Federal Ministry of Justice, others the ministries employ directly. But there ought to be a coordination between the legal departments of the various ministries and the departments and the Federal Ministry of Justice, because, like I said previously, the Attorney General of the Federation is the Chief Law Officer of the country. And so for me, he has the responsibility to coordinate all contractual arrangements of the federal government. Sadly, there were gaps in this case because the head of legal of the Minister of Petroleum Resources at the time, Mrs. Grace Tiaga, was the person who solely dropped the agreement without recourse to the Federal Ministry of Justice and Attorney General's office. And then, on the basis of the technical committee that was put up in place by the ministry to review, to scrutinize the award of the P&ID contract, the contract was awarded to P&ID without the input of the Federal Ministry of Justice and the Attorney General of the Federation, and without the contracts having to go through the Federal Executive Council. Don't forget, during the threshold, the monetary threshold of the contract, the allegation is that it ought to have been referred to the Federal Council at that time for approval, but it was not done. So essentially, Mrs. Grace, the Chief Legal Officer at the time, was responsible for drawing up the contract and presented it to the then Minister of Petroleum Resources, the late Dr. Rehan Lukman, for signature based on the recommendation of the technical committee headed by one Mr. Tijani. Omoaka.
Okay, that's quite interesting because it seems that we have the issue of handing over one administration to the other and people doing things unilaterally without consultation. So are there no laid down procedures? You mentioned the fact that the Attorney General's office is supposed to consider this contract, make sure that it looks into the terms of the agreements and all that. Can a government procure contracts, enter into contracts without even becoming aware that it has entered such contracts?
Now, I don't think it is correct to say that the government is not aware. The government is aware. I think the only thing is that the Attorney General was not aware. The principal parties of government at the time were the Minister of Petroleum Resources, the late Dr. Iwalu Lukman, who approved the contract, the head of the technical committee of the ministry, who had to scrutinize the bid process, I think Dr. Tijani also, and then, of course, Miss Grace Tiaga, who was the head, legal. So, I mean, outside the Attorney General, these are the people who are key government officials in that ministry. You can't go higher than them. I think they ought to have contacted the office of the Attorney General, given the significance of the contract to the Nigerian economy and potentially Nigeria's exposure and liability in the event of a breach. And don't forget, like I mentioned earlier, the monetary threshold of the contract was quite high. And so again, it needed to get the approval of the president at the FEC, right? So I think that's where we are talking about whether the government was aware. But the ministry, the minister, if an agent of the president who signed the contract, the president will go on simple basic agency relationship, is the principal, the minister is his agent, and so the federal government is bound because you are dealing with the case of an agency of a disclosed principal. So I wouldn't say that the federal government was not aware.
Okay, so the basis of the federal government initially contesting the P&Id agreement, that it was totally not aware, because this question came as a result of the fact that there should be handover notes from one ministry, agency of the government and all that to the other, from one tenure to the other. There should be continuity in government. That is why we are trying to find out how a government can say it is not aware of agreements reached on its behalf.
I think yes, that's why I said it's a good question, because it's not a question of incompetence on the part of the responsible government officials. You cannot say at that level you are not aware. You know, like you rightly noted, government is a continuum from one government to the other. Once a government takes over, then it inherits the contracts and the rights and liabilities of the other government. So whatever has been done by the previous government is deemed to be an act of the government which took over from it. So the contention or the argument that government is unaware is just looking for who to put blame on needlessly. Government officials are aware, and it's about time in this country that our government officials own up and take responsibility for their misdeeds. Many a times what we are confronted with is a lot of buck passing, and I don't think that is fair to the Nigerian people. I don't think it is fair to the Nigerian government, to whom they are Nigerian people, to whom they are supposed to be accountable.
Okay, that's quite true. Government should be accountable, and every document, every contract you enter into, you should actually take it seriously. We'll go on a quick break. When we return, we'll get in more details as to how that judgment of the P&Id contract was overturned in favor of the Nigerian government. Just after the judgment debt was revisited in favor of Nigeria, a United Kingdom judge has ordered P&Id to make an interim payment of more than £1.5 million to Nigeria within 21 days to cover legal costs the country incurred as part of its successful application for the extension of time to challenge the arbitration award of $9.6 billion to the company. The judge gave the order when Nigeria appeared before it in a hearing to decide procedural and cost issues relating to Nigeria's applications to challenge the arbitration award and to determine the short-term directions to trial. This latest order follows the major victory the nation secured when the court allowed the country to bring a fraud challenge against a $9.6 billion arbitration award obtained by P&Id well outside the normal time limits. With the order, Nigeria will now proceed to a full fraud trial in its quest to avoid paying the arbitration award, which is estimated to be 1/3 of the national budget. The Nigerian government has maintained over time that the contract that led to the arbitration was fraudulent and that it would work relentlessly to overturn it. You're welcome back. You're still watching The Courthouse, and we have our learned senior advocate of Nigeria, Godwin Omoaka, who's been talking about the P&Id case and how Nigeria actually entered into such an agreement. So this time around, we want to find out from you, Leonard Silk, how come, how did the Nigerian government, did the Attorney General actually successfully get a judgment overturning that contract or that judgment sum?
Okay, before I deal with that, let me go back a little bit. Now, what happened? When P&Id alleged that Nigeria breached the contract, P&Id referred the disputes to arbitration in London. London was the seat of the arbitration. Now, Nigeria brought what was called a jurisdictional challenge, challenging the jurisdiction of the tribunal. The tribunal issued an award against Nigeria on the jurisdictional challenge. Then, of course, the matter proceeded to hearing, and then the issue of liability had to be determined. Again, the tribunal found and issued an award that Nigeria was liable for breach of the contract. So you have two awards, the jurisdictional award and the liability award. Then what was not left to be determined was the issue of quantum, the quantum of damages that was paid. And again, the tribunal found by a majority of 2-1, I think a Nigerian who was part of the arbitral tribunal dissented. The tribunal found by a majority of 2-1 that Nigeria should pay, and did order Nigeria to pay P&Id $6.6 billion. And that was the original award sum, with interest at the rate of 7%. And over time, that increased to about $9 billion and eventually to about $10 billion at the time Nigeria became successful in its application to challenge the award. Now, after the award, so we had three components of that award: the jurisdictional award, the liability award, and the quantum award. Now, what Nigeria did when we became aware of the quantum award, then it was $9.6 billion, and it became a big issue in the country because even our federal reserves, we didn't have that amount of money in our federal reserves to be able to pay. Then the Attorney General stepped into the matter. Initially, Nigeria tried to negotiate with P&Id. It didn't work. It wasn't successful. And the Attorney General had to instruct foreign counsel in the UK to approach the courts in the UK to set aside the award. I must give credit to the Attorney General. Given the kind of law firms that he worked with, the kind of firms that were instructed, they were some of the very best law firms in the UK. For instance, Mission de la Rey. Before that, we worked with Curtis Marley. And then lately, the instructing solicitors for Nigeria was Mission de la Rey. And of course, they got Mr. Howard, who was one of the best advocates, barristers in the UK to pursue this case. And what was Nigeria's argument? But before we get to Nigeria's argument, let's step back a bit to what happened. Before then, the English court, P&Id, had sought to enforce the award against Nigeria. And the English court had granted P&Id leave to enforce the award. So What does that mean? What was the implication? They were going to be looking for Nigerian assets all over the world to either sell or confiscate so that they could realize the judgment, the award sum. All right? And it was at that point the Attorney General said, no, we need to do something, and then instructed all of these law firms and very clever people, very smart people, and they came together and said that, look, given the endemic nature of corruption in Nigeria, it is not impossible that this contract will have been awarded as a result of bribes and corruption, bribes to public officials, and then an investigation began. The EFCC began to investigate how the contract was awarded, and in the process, it was discovered that a lot of government officials were corrupted. They were bribed. They were bribed in the process. The AG of the Federation had to initiate proceedings against some public officials. Those proceedings are ongoing. P&Id itself was convicted in Nigeria recently on the grounds of fraud. Now, fraud is contrary to public policy in any nation of the world. And fraud is a basis to set aside any kind of award, arbitral or judgment. So the Nigerian courts now, the Nigerian government through its lawyers now approached the courts in the UK seeking for two main reliefs. One, extension of time to bring a challenge to the enforcement proceedings under Section 67G and 68 of the English 1996 Arbitration Act, and again for relief from sanctions so that Nigeria can present evidence to challenge the purported enforcement of the arbitral award. And Nigeria's case was based on three planks. The first plank was that the GSPA, the Gas Sales Processing Agreement itself, was procured by fraud. The second plank was that the arbitration agreement contained in the GSPA was procured by fraud. And the third ground was that the award itself, the arbitral award itself, was the product of fraud, and therefore you cannot enforce it because fraud is even contrary to public policy, all along English public policy. Nigeria made these arguments before the court and brought credible evidence that indicted a lot of government officials in the award process. Some of them got money, $10,000, $20,000, and all of that. And because of that, what has happened is that the English court has said that there is prima facie, on the face of it, there is prima facie strong grounds to believe that the award was procured by fraud. It has not ruled on the issue of fraud. That will go to trial. But it says, look, looking at the entire set of circumstances, I believe there is reason to proceed to a trial as to whether there is fraud. I can see that a lot of questions have been raised. So the judge said, you know what, Nigeria, I am going to stay the execution or the enforcement of the award, and that is what has been done. It has stayed the enforcement of the award against Nigeria and has given Nigeria, granted Nigeria's application for extension of time to challenge the award and relief from forfeiture. So now what is going to happen is that the matter will now go back to the English High Court for trial of the question of fraud. That is when Nigeria will now be able to prove whether indeed there was fraud in the award of the GSPA itself. If Nigeria succeeds, then the arbitral award will eventually be set aside. As it is, it has not been set aside. What has simply happened is that the English court has granted Nigeria's application for extension of time to challenge that award and to suspend the enforcement of the award. So that's the point where we are at the moment. The matter will now have to be set down for trial before the English court on the question of fraud. And once Nigeria can establish that fraud, then that award will be set aside. So it's not yet victory completely.
Okay, but we hope
that's part of victory. It's a very good development for Nigeria, and seeing the skeleton arguments that have been presented, reading the award as I have done, and seeing the evidence that the EFCC have
presented. Okay, so that's actually progress, and it's a good one for Nigeria. Let's just end with this question. The sovereign guarantee clause inserted in Nigeria-China agreements has been raising serious controversy. Is this not similar to the P&Id saga? Will it give us that type of scenario?
No, it is not at all. I think, to be honest with you, there's a lot of ignorance on the part of the Nigerian legislature and the Nigerian populace about what that waiver of immunity clause in a contract is. It's a standard contractual clause, and there's nothing absolutely wrong on it from a contractual point of view. Now, even if Nigeria does not have that waiver of sovereign immunity clause in the contracts with China, the Nigerian courts, the IPCO case, have held that once a government goes into a contractual arrangement, then the government cannot seek to excuse itself from liability by saying that, oh, I am a sovereign state. You have taken benefit of a contract. So what is happening in this case is this. Nigeria has borrowed some money from China, all right? Loans. This is a commercial arrangement. This is a commercial agreement. Now, if Nigeria should default in the payment of those loans, then the question is, how does China recover its money? And that is where the issue is. And Nigeria has waived its right to sovereign immunity in relation to those assets. Yes, that China is building, because China is giving you money to build a railway. Now, China must have a right of lien over that railway in the event that you default.
The challenge is that China has a track record of actually taking over major national assets, and people are warning that Nigeria doesn't really need to get into such contractual relations with a nation like China, knowing that the interest will be do have too much vested interest in Nigeria. Will probably take over everything if we end up borrowing and borrowing and borrowing without stopping.
I agree with you, and that is where the issue of corruption, the issue of the insincerity of Nigerian government officials come in. China, we know, is a very, very, I would say it's a country that without credibility. Look at what they are doing in other parts of Africa. And so the fear is real. I don't put the blame on China. China has money and is willing to lend money. I put the blame on our own government officials. When we have the amount of corruption we have in this country, the lack of sincerity in governance, the lack of accountability, then look at where we are today as a nation. We need to get our acts right and put our hearts together. Because to be honest with you, it's not just China. All of these countries are out there to perpetrate their own interests.
Okay, thank you so much. Thank you so very much for throwing more light on this sovereign guarantee issue, and of course the P&Id saga, bringing us up to speed with what happened in the past and the current state of affairs now. Of course, we are hoping that Nigeria would fully succeed when the case gets to full trial. That's the much we can take with you. But you know, we have our bar book segment, and you've used some Latin maxims. You've talked about prima facie. Can we know what prima facie is?
Well, prima facie simply means on the face of it, on the surface, right? Okay. There is reason to proceed. So that's what prima facie means, on the face of it.
Well, thank you so much. Yes, you get to find out more Latin maxims and their meanings in our bar book segment. Okay, well, that's the much we can take this week on the Courthouse. We must say a very big thank you to our Leonard Silk for making our time to be here on the show this week. And we want to remind you that we have our special question and answer episode which is coming soon. So send your questions. We have our panelists, our legal experts who are ready to provide answers for you. In fact, pro bono services, that's another Latin word, free services for you. And I am Olomu-Agbodo. Don't just get mad, go get a lawyer. Bye for now.